Hello, my name is John Altmiller. I'm an attorney with the law firm of Pesner, Altmiller, Melnick, Demers, and Steele. And I'm here to talk about some of the aspects of practicing real estate law and specifically litigation. Now, before I start, I want to talk a little bit about what it's like to practice in Virginia and talk about specifically the professionalism and collegiality that I've experienced over the last 30 years. Now, I was not fortunate enough to have a mentor when I started practicing. And so I learned a lot from many other lawyers who helped me along the way. And one of the things that I've learned is that the attorneys that you come to ask for help are most often very willing to provide that help to you. And if you don't know the answer to something, you should never be afraid to ask. And this is true whether you're dealing with an attorney that you know or that you don't know, or even an attorney that might be on the other side of a case that you have. Contrary to the popular depiction of attorneys, most of us are very collegial. We work well together, we ask each other questions, and even if we've been practicing a long time, we might come across something we don't know the answer to. I know that I always feel free to call my colleagues when I have questions, and they feel free to call me. A lot of people help me on the way up, and I certainly have been more than happy to return that favor. So I think it's helpful when you think about the practice, and I'm going to talk about some specific things related to litigation, but to think about it in terms of contributing to a legal system that you are a part of and that relies upon you. And so when we talk about, and when I talk about litigation, it is adversarial by nature, but that doesn't mean that it needs to be excessively adversarial. So I want to talk about a couple of issues related to legal title. And I want to talk about the ways that somehow or sometimes that we litigate these issues to resolve those matters. So the types of issues that we're going to talk about relate to circumstances that occur when there's disputes over whether or not somebody owns property, or there's a dispute among parties who co-own property, or even where there's a dispute involving what we call adverse possession about whether or not somebody can gain title to property even though it was not granted to them. So I think it's helpful in thinking about these issues to think about the role of the court in matters of title to real property. So people think sometimes about somebody's name being put on title or taken off title. And I think sometimes they think of it as if there's a box somewhere in land records where you add something or you take something out. In reality, the land records are sort of like an archaeological dig. Everything that gets recorded in the land records stays in the land records forever. Now, that doesn't mean there won't be things that come after it that will invalidate or confirm that what's been recorded previously, but it does mean that you are dealing with sometimes competing interests in which two documents have been recorded in the land records that might be at odds with each other. How do we resolve that? There may be a dispute about whether somebody has a claim to property even though they don't have anything in the land records. So I'm going to talk about three different areas specifically. And this is not meant to be a thorough discussion of these issues. I'm not intending it to be an in-depth look at these issues, but rather a broad way of looking at the types of things that I litigate and how we use the courts, and specifically the circuit court, to resolve these types of issues. So the land records are, and ownership of real property is really the domain of the circuit courts in Virginia. So if you have a dispute, that's where that dispute is going to get resolved. So the first thing I want to talk about is a suit to quiet title. And a suit to quiet title can arise in a number of circumstances, but it's almost always going to be in a situation where two people are, or more than two people, are arguing over who owns property, or what their respective rights are. Now, that can evolve in a number of different ways. So, for example, one of the things that has been happening lately, as incredible as it may seem, is that people are impersonating owners and selling their property. So what do you do if your client calls you up and says, I have a house in Fairfax, I was down in Florida for the winter, I came back and my key didn't work and somebody else was living in my house. Now that sounds a little crazy, but it actually can happen. You can have a fraudulent deed that gets recorded. What do? The person who's in the house says, I have a deed, I own the house. Then you say, well, I have a deed, it says I own the house as well, and that deed that you have was forged. That is when you go to the court and you say, we need to figure out what or who owns that property. And that is one example of a suit to quiet title. There are plenty of other examples where people might say, challenge whether or not a deed conveys a certain amount of property, or what the legal description is, or whether or not somebody had capacity or the authority to convey title. So there are numerous circumstances in which that can arise. The important thing to understand is that when there is a dispute between two or more parties regarding ownership of property, normally the way that you are going to resolve that is through a suit to quiet title that you would file in the circuit court. I would also mention, because there is a connection between the circuit court and the land records, that whenever you have a claim, if you have a client, they have a claim saying that they own property or that they have a right to property or an interest in property, and maybe it's not reflected in the land records, in order to put everybody else on notice, you would file what's called a memorandum of lis pendens. So it's very important when you're thinking about these issues to say, how am I going to communicate to everyone that there is this claim? And this really gets to the heart of what the land records are supposed to do. The reason we record the deeds that we sign and deliver is so that everyone else knows, so the world is on notice. Everyone has what we call in the law constructive notice, that a certain thing has happened, a certain interest has been conveyed. So that's something that if you are in the practice of real estate law in the area of litigation, or even if you are just practicing and you're not a litigator, to be able to identify this is something you are going to be coming across. And you want to be able to identify that that is how an issue like that is resolved. Now, the second thing I want to talk about is partition. And a partition suit is simply when two or more people own a property together and they have a disagreement about what their interests are in the property, or they will have a disagreement where one wants to sell the property and one does not want to sell the property, or what the property is worth if one is going to buy out the other. These are issues that are resolved in a partition suit. A typical suit may arise, in fact does arise, when two or more people inherit property. In Virginia, unlike other jurisdictions, when somebody dies, the property normally, real property, does not go to the estate. Instead, it, as they say, drops like a rock to the heirs. So you could have a parent pass away, and that parent's three children are now the owners of the property. Maybe one of them lives there. Maybe one of them has lived there for a long time and doesn't want to move and doesn't want to sell. Or maybe they just are disagreeable. Maybe they have disputes that are long-standing and this is their last chance to resolve them. What a partition suit allows parties to do is a couple of things. One, you can figure out whether or not you have more of an interest. So if two business partners buy a property, they own it for 5 years, maybe one of them has paid all of the mortgage. Maybe one of them has taken all the rent. Maybe one of them has made a significant improvement. If the property's sold, we need to figure out how to divide the proceeds. Simply because they own it 50-50 does not mean that's how the proceeds will be divided. So these are the things that you look at in a partition suit. Furthermore, as I mentioned, you may have one or more of the owners who don't want to sell and one of them who does want to sell. What the partition suit allows to have happen is to have that property sold, and the court will, after determining what the parties' interests are, order the property to be sold by a commissioner of sale, or they might allow one of the parties to buy the other party out in what's called an allotment. Again, I don't want to get into the details too much about a partition except to explain the concept and when it will come up, and to recognize that there are rights that property owners have even when they own property with other folks. So that would give you a clue as the type of cause of action and the type of lawsuit that would be involved in resolving those issues. The third cause of action, or the third type of case that I want to talk about, is adverse possession. Now, adverse possession essentially is a circumstance in which one person uses somebody else's property exclusively and continuously for a period of time. And if they do that for a long enough time, they become the owners of that property. Now in Virginia, that period of time is set by statute, and it's 15 years. Now, the law of adverse possession is one that's actually fairly well developed in Virginia and really more common than you might think. I've seen numerous cases in which adverse possession has been granted by courts. If the elements are established, the courts will do it. They will render one party an owner of property that they did not previously own. I've seen cases, more obvious cases, where somebody maybe builds a fence, but I've seen cases where somebody has literally mowed the lawn and planted flowers on a property for more than 15 years, and as a result has become the owner. So although the area of adverse possession, or the area of law of adverse possession, is a potentially complex and nuanced area of the law, it is one that comes up far more often than you would think. And what's unique about it, as opposed to the first two causes of action that we discussed, is that it is a case where somebody can become the owner of a property despite the fact that they were not expressly granted an interest in that property. So when you look at an adverse possession claim, you really are looking at somebody who is going to become the owner of a property, sometimes not only despite the fact that they don't own it and that they had no right to use it, but oftentimes because they have done that, because there is an element that's not just that it's exclusively used and that it is continuously used, but that it's done under a claim of right. It is done hostilely, as they say, to the rights of the true owner. Now, it has to be obvious, it has to be open and notorious, as the courts say. But once those elements are met, there is actually very little limitation in how one party can obtain ownership of another party's property. And it also means, particularly in a more suburban setting, lots of times you can have people who build fences, who cultivate parts of a property that are owned by another. And because it's very rare to have people actually stake out their property, it's not unusual to do a survey and find out that somebody's fence has been over the line, and maybe it's been over the line for a very long period of time. And the law in Virginia changed, certainly during my practice, or at least changed in the way people thought about it, in that you can adversely possess property by accident. So if somebody accidentally builds a fence over the line, it's the same as if they did it on purpose. And so, normally, if you're doing something accidentally, it's not as bad as if you do something on purpose. Here, it's actually either the same or better if you're doing it hostilely. So the thing about adverse possession for a lot of folks is it seems contrary to their common sense. You're taking something that's not yours, you're doing it on purpose, and the law is rewarding you for it. But really what the law is doing is the law is saying we are going to let the people who are actually using the property and the people who are making it productive be the owners. It's a policy choice, and it's a policy choice that's been made for hundreds of years and in pretty much every state in the union. So these are the types of cases, or three of the types of cases that I deal with as a real estate litigator. Now, what they have in common, as I indicated, is that you are getting the circuit court to make a definitive statement about the ownership of property, and it is hard to overstate how important that is. It is shot through all of the law that you encounter in civil law, all the types of cases that you have, is the basic primacy of ownership of real property. It is, as one comes to find, the basis for a lot of economic activity, a lot of the order, if you will, in how a community operates. Now, it can expand to things like land use and zoning. It can deal with issues like easements, not just who owns the property, but what their rights are, issues about nuisance or trespass. But what I'm talking about fundamentally is establishing who owns property. Now, what you end up getting when you do that is you get a court telling you, here's an order, and here's who owns the property, or here's who doesn't own the property, or here's what's going to happen to that property. And those court orders essentially have the same effect as if the parties had gotten together and executed a deed. I do want to say that because these areas of the law are occasionally, and maybe more than occasionally, difficult, nuanced, there's not necessarily a lot of law about some of these issues that will arise. And for that reason, there is a lot of discussion among lawyers. It is not unusual to come across a real property issue for which there does not appear to be any direct authority. And when those type of circumstances happen, it is not unusual for even the most experienced practitioner to reach out and to ask their colleagues what they think, to circulate an email, even if that colleague might be their opposing counsel in another case that they're dealing with. I'm going to conclude my remarks, and I wish everyone well in practicing what I consider to be one of the great places to practice law, particularly for a litigator. And I wish everyone well. Thank you.